So welcome to the channel that tries to simplify financial planning law for financial advisors in the South African market. So welcome to the channel that tries to simplify financial planning law for financial advisors in the South African market. Now, when I use the term financial advisor, I'm using it broadly. It includes people like brokers, financial consultants, financial planners. I think the point is, as long as you are registered in terms of Financial Advisory and Intermediary Services Act, you're basically a financial advisor, just for the sake of using a generic term. Now, when you're looking at a financial advisor and financial planning law, it's quite broad. I mean, we could be looking at things from estate planning to retirement planning, all the way to business assurance, and in that in itself, there's a whole host of laws. For example, you could be looking at trust laws, you could be looking at income tax. There's a whole lot of legal issues that we can discuss within the umbrella of financial planning law. So what we'll be trying to do is segment everything, and everything will be in different videos. We'll be discussing certain topics, and some videos might be a series of videos because the subject matter is just a bit broad, so we'll nitpick on short videos and particular points. Otherwise, some videos might be a solo video which just basically describes a particular a concept, which is easy to explain in a short video. So if you look at advice in terms of the Financial Advisory and Intermediary Services Act phase, you remember, I'm not going to put it out now, but you remember that advice is always a recommendation, a proposal, or a guidance that is coming from the financial advisor to the client. And if you look at the definition there, it's always in respect of a financial product. So the issue of products cannot be ignored. Now, although the channel is meant to look at the legal aspects of things, but we cannot ignore the solutions that are ultimately provided by the different products that are offered by our financial services industry, which is quite innovative. I mean, our banks, our insurers, the number of products that are out there do solve a lot of the things that are that come out from legal problems that the clients have, and these solutions in the sense of products actually solves those problems. So the issue of products, we will mention it where it is necessary, but we won't be doing a product comparison between companies. I think what's important though is because we know we do interact with products where it's needed. For example, so if you take a space of buy and sell agreements where we're looking at shares, maybe bring in a speaker that can speak about underwriting, so you won't just be hearing my voice, who will tell you how do they manage the valuation of shares, what do they need from the client that you've seen in order to put in place a certain product that's going to solve the client's problems. So from a legal perspective, I'm hoping to explain certain legal concepts that will ultimately help you manage your practice in a far better way and unlock other opportunities, other financial planning opportunities for your clients, and structure things properly with the input from a legal perspective. And I thought maybe just to demonstrate, I'll do a quick example. So here's an illustration. So I've just made up a couple of facts. In fact, these facts, unfortunately, they commonly happen, and it's something that we deal with frequently, and I just thought I'll water down the facts just to illustrate the point, but it's something that we need to consider. So in terms of my facts, I've got a couple. I've got Mdu, who is married to Angel, and they have a 5-year-old daughter, and her name is Punki, so she's a minor. Now, according to my facts, unfortunately, the couple suffers a bitter divorce, and they split up, and the court order grants the divorce, and everything's split up, and they handle everything in custody. All of those matters are handled separately. Now, Angel approaches a financial advisor and says, look, I'm a single parent, I am divorced, I had a bitter divorce, it was nasty, as many of them are, quite frankly. And then she says to you, well, I need to look after my daughter in the event of my death or disability or whatever. I need to make sure that she's taken care of in terms of accommodation, schooling, until she becomes of age, until she can look after herself. So this is what the mandate is from Angel. So what Angel could possibly do is take out a life policy. So as you can see there, she can be the owner of the policy. She's a life assured. Obviously, she's a trigger. If death occurs, then the payout happens. She pays for the policy. Now the question is, who becomes the beneficiary? Now, when we just chitter chattering, it's easy to say, well, just make Punky the beneficiary because that's where the funds should be. However, that can create a couple of problems. In the event of the death of Angel, that means the policy will pay out this way because Punky is the beneficiary. Now that can create a couple of problems for Angel. By that I mean, remember that she has gone through a bitter divorce, which means the relationship are obviously not good with the father. And in the case that I had, which is a real life case, they said that the ex-husband had been an alcoholic, a gambler, and all sorts of things. But now, if those funds are payable to Angel directly, and the father is still alive, in our example, Mdu, that means as a natural guardian, he has the authority or he has the right to manage those funds for his minor daughter, unless a court of law says, for example, that he is unfit to be a parent or something like that. But without that kind of information, whatever appears as a beneficiary in terms of the beneficiary nomination from an insurer, they will want to pay Punky. Now, those funds ultimately are going to be controlled by the father, whom Angel might have not wanted to control. And I think it's worth mentioning that had the facts been different, let's assume that Mdu and Angel were never divorced and they were still happily married. Then if Angel had to take out a policy and perhaps made the husband the beneficiary, then there's no problem because they're happily married. If she passes on and the husband is the beneficiary, then she's at peace that he will look after the daughter Punky, so there's no issues there. And the nice thing about that is that at least at that point, when Angel passes away and policy pays to Du, who is the beneficiary, you get the Section 4Q deduction, which means those funds will not attract a state duty because Du is a spouse of Angel's. So that's entirely different. But in our case, we're going to carry on assuming that they had a bitter divorce. So the second alternative that we could look at is have the policy payable directly to Angel's estate. So the beneficiary nomination is just basically left as the estate of Angels. Now, while this proposition is good, because if you think about it, if Angel passes away, we need liquidity in the estate in order to wind things up. She could be owing taxes or debts or whatever the case may be. So to have that liquidity coming into the estate is a great thing. However, that was not the mandate that the client's Angel had given you. Angel had requested that we set aside funds to look after her daughter in the event of her death. The issue of liquidity in the estate and providing those funds is a completely separate issue. We're trying to demarcate funds that will look after the daughter. If, for example, Angel, let's assume, for example, that the policy is R1 million and the policy, which was intended to look after Punky, pays into the estate. However, there's a debt of R1 million in the estate. What happens to those funds? They get swallowed up by that debt, and therefore Punky gets left with nothing. So that's the problem there. The second thing is that because the funds are paying directly into the estate, now we're going to start attracting executors' fees, because the minute those funds come into the estate, the executor is going to manage those funds in terms of paying those debts that I just spoke about. Or if there's a surplus or there's some change left to look after Punky and distribute to whoever the heirs are of the estate. There is, however, a third option where we can nominate a trust to be created in terms of the will. So in terms of the beneficiary, you could perhaps just state their testamentary trust in terms of my will. Now what that would do is to make sure that the funds are paid directly to a trust that is created in terms of the will. Now what this option does is to give the Angel far more flexibility, because in terms of the trustees, she could possibly, let's say for example she has a brother, she could nominate a brother as one of the trustees. So the niece, she can rest assured that the niece will be looked after, because as a brother, as being one of the trustees, he knows who Angel is, and he can take decisions with whoever the professional other trustees are. So that's another thing that this allows you to do. So you can introduce professionals. Now it's all good and well to leave funds to your child and even have things like your garden fund coming in, which is run by the government, but they've been having a couple of problems, from anything from fraud to whatever the issues that they were having. So you don't want to leave the funds there. If there's an option to do it, let's rather do it professionally. Now with this third option, with the funds paying into the trust, number one, it negates executors' fees, because the funds never hit the deceased estate, angel's estate. So the executor never gets to manage those funds. The funds are directly paid to the trust by the insurer. And then secondly, the issue of estate duty, unfortunately, is still going to be there because the beneficiary of that trust is going to be the daughter. Unfortunately, as the law currently stands, the Section 4Q deduction is only available to spouses, and the Davis Tax Committee has looked at some of those things, but as currently things stand, that benefit is there just purely for spouses. So I hope this little demonstration was helpful, and it just shows you some of the implications of choosing minors as beneficiaries in life policies. And by the way, when I talk about life policies, this includes endowments because it has a life assured. When it comes to things like your other investments, such as your collective investment trust, your unit trust, your shares, and all kind of stuff, that gets treated as property. And in terms of taxation and all of that, that's a separate discussion. But in this format, when you're talking about life policies, we can actually achieve angels' wishes by constructing it in this manner. So if you enjoyed the video and you find it helpful, please do subscribe so I can bring you more content. And I'm hoping to do at least one video per week. And like I said, depending on how on what topic we're discussing, some videos will have different segments within the broader topic. So please do subscribe, and I'll chat to you again soon. Thank you.